thoughts on the recent budget proposals relating to tax. First, I think we can discuss about the direct taxes. Good news is there is no change in the rate of tax or there is any slabs. So nowadays, if the honorable finance minister doesn't change the rates of income tax, we must be thankful. Apart from the announcements made for the senior citizens above 75 years old, exempting them from filing the income tax returns provided their income is composed of pension or interest alone. And the tax holiday being extended for the startups by 1 more year. There is nothing much to talk about the rates, but there are a lot of things to talk about the legislative changes. The first thing I want to mention is the formation of a committee called Dispute Resolution Committee for small assessees whose income return is less than 50 lakhs and the variation in the valuation or the addition of income is less than 10 lakhs. These can be disposed of by the Dispute Resolution Committee. While we were happy that these types of small disputes can be disposed of by the Dispute Resolution Committee, what was a shock to me was the abolition of the Settlement Commission itself. With effect from 1st of February 2021, as of today, we are talking about, the Settlement Commission will no longer function excepting for the pending cases. In other words, assessees who want to settle the matters cannot file new applications before the Settlement Commission. I would say that any government should be interested in ensuring that disputes are settled when the assessee wants to settle. And instead of strengthening and widening the scope of the Settlement Commission, I am seeing today that the Settlement Commission itself is getting abolished. I would say it is a retrograde step. Coming to the advance rulings, we have been seeing in the past that the number of advance rulings are less, pendency was more, to ensure that the appointment of the judicial members are being done. What we see now is the existing system of advance ruling headed by High Court judge or Supreme Court judge is dispensed with for direct taxes. It will now be heard or disposed of by board for advance ruling consisting of chief commissioners, principal commissioners, etc. There will be no judicial members or presence of retired High Court judges. We are now seeing similar provision as far as the advance ruling are concerned under the GST, where the quality of the advance rulings are much to be desired. I don't want to say anything more. I don't want to be a doomsday soother. But again, this is not the right direction. We had a good announcement by the finance minister that the reassessment proceedings will be now reduced from 6 years to 3 years. I was happy. But when I went through this fine print, I find that this is applicable only in respect of reassessments where the amount involved is less than 50 lakhs. In all other cases, it is 10 years. Subject to correction, this is what I read. I will again check it up. But my reading and my colleague reading says that the 6 years for more than 50 lakhs has actually gone up from 6 years to 10 years. This is not the right direction if we are saying that we want to reduce the uncertainty. We are only increasing it. With regard to the faceless assessment, faceless appeal last year, now they are coming to the faceless appeal before the ITAT itself. Your appeals will be heard by any member, any tribunal, any bench, anywhere in India. And hearing will be granted whenever they feel necessary, not when you want it. And the hearing will be mostly on the video conferences. I do not know how far these provisions can be legally valid. Right of being heard before a person's tax liability is finally settled with the tribunal, I would say is inherent right and one of the basic pillars of natural justice. If that is taken away, and if it is a discretion of the tribunal to grant you hearing or not, how far such provision will be valid in the eye of law is yet to be seen. The grant of depreciation on goodwill was always a matter of dispute. The courts have held that goodwill being a capital in nature, the persons concerned would be entitled for the depreciation even on goodwill. Now the law has been amended specifically to say that no depreciation will be given for goodwill. All M&A transactions, lawyers, consultants, chartered accountants must take note about this important amendment which has been made. These are the broad things I wanted to check, tell about the income tax. As for the indirect tax are concerned, in GST, not much need to be stated because the powers of the finance minister is very much curtailed unless there is recommendation from the GST council, though of course she is the chairperson there. So therefore you don't see much changes in the budget proposal on GST, except the amendment when made with regard to the clubs and the members. They've been treated as different persons, and therefore this will constitute supply. The supply definitely have been taken, have been amended to take care of this. And there was one more short point where the goods are in transit, where the officers retain and confiscate the goods because the tax-paying documents are not available or some discrepancies. The earlier section said at the time of release, you must pay the penalty and also the tax. There was always a dispute whether the tax already been paid earlier should again be paid or not, etc. So now they have taken away, they have amended the section to say that at the time of release of the goods, you pay penalty equal to 200% of the tax. 100% tax. Now 100% tax and 100 penalty is equal to 200% of the tax equal to penalty. I think these are the broad changes which have been made in the GST. Now we come to the customs. An important provision has been made under the customs. First of all, a new levy has been introduced called Agricultural Infrastructure Development Cess. I call it as AIDC. This levy has been introduced. The rate of tax, rate of cess is equal to the rate of custom duty applicable on all imported goods into India. For example, if a commodity being imported into India is attracting tariff rate of 30%, equal amount of 30% being levied on the same item under the AIDC also. So by parliament levy, they have imposed equal amount, 100% of the custom duty payable on the imported goods at the tariff rate level, not with the exemptions. And Provisional Collection Taxes Act 1935 made applicable. Therefore, it is effective from today, tonight. Tomorrow morning onwards, it will happen. Now the question here is, this levy will be collected like another custom levy. In fact, it's called custom duty. Therefore, by one stroke of pen, the custom duty has been doubled. The saving grace is, by an exemption notification, this levy has been restricted to certain commodities, but nothing prevents the government to expand the list and add more and more items under the category AIDC. While doing so, one must be very cautious. The existing levy is already equal to or slightly less than the bound rate which we are given to the schedule of concessions. And if this cess also being levied, sum total of it, if it is going to breach the schedule of concessions, then we will be not complying with the schedule of concession at WTO at the time we joined. So one has to be careful about that. Apart from the AIDC, one important feature, welcome feature, is the amendment or introduction of a section called 28BB, where for the first time, the customs, they brought about a time limit for issuing a show cause notice whenever there is an audit or a search which has taken place in an assessee premises. The officer cannot take his own sweet time to issue the show cause notice. It is 2 years now. With exception, 1 year extension can be given by the principal commissioner. But otherwise, there is a definite period before which the show cause notice has to be issued. Otherwise, the proceeding will abate. Another important feature which has been brought is an amendment to Section 25. As Section 25 of the Customs Act basically provides or empowers the government to issue exempt notifications. These exemptions are two kinds. One is called unconditional exemptions, otherwise conditional exemptions. Unconditional exemptions are tariff rate 25%, I reduce 15%, no conditions. Conditional exemptions are tariff rate 25%, I reduce 15%, provided this product is used for a particular purpose. So, and this is one example. There are several conditions possible. In all those conditional exemptions, a sweeping amendment was made. Existing notification as on today midnight will all expire on 31st March 2023. And in future, any conditional notification being issued will be valid only up to 31st March on the second day following the day when the notification is being issued. This is an auto review mechanism because many times the notification were issued for a particular purpose. The purpose may no longer be applicable in future. So it is a good provision where the government will necessarily, compulsorily examine whether a particular conditional notification should be extended or not. This also will put pressure on the assessees who are enjoying the benefit to justify that this exemption is needed even for the future. So there is a good mechanism by which the assessee should seek and there will application of mind by the government to extend the benefit or not. Up to this point is fine. The more important thing is amendment made to anti-dumping provisions. These are very important amendments were made. Here, first one is they introduced a new section for anti-absorption measures. In a situation where anti-dumping duty has been imposed in respect of goods emanating from an exporter from a particular country, it is expected that the importer is bearing that custom duty, anti-dumping duty, and the prices are remaining the same, and in which case the volume of import will come down, not naturally. But in cases where the exporter picks up this cost and reduces export price and starts exporting to India at the same price, more or less the same price, and the volume of import continue to be the same, there is a ground for the government to allege that the exporter has absorbed the export duty or the anti-dumping duty, in which case they can start investigation as to whether this is properly done or not. This is an important provision. But I must submit one thing, that in the recent past, the finance ministry has been taken a position whether they should impose definitive anti-dumping duties even where the designated authority has recommended the levy of anti-dumping duties. I have seen in the last 6-9 months about 18-19 cases where the designated authority has actually recommended the anti-dumping duty, but the finance ministry has refused to impose anti-dumping duties. Now, in this budget, duties have already been imposed in the past, anti-dumping duties. In respect of 3 commodities in the steel sector, the first time in the history of India, the government has suspended the levy anti-dumping duty up to 30th September 2021, starting from today. I see this as a signal to the domestic industry that by levy of anti-dumping duties, if the domestic industry increases the prices abnormally and the user industry gets into financial difficulties in the extreme difficult situation today, that by the COVID and other things, the government is sending a signal that it is not as though we are going to always err in the side of domestic industry. The user industry is also part of the economy. In fact, domestic industry and the user industry are 2 eyes of the government. One can't harm the other to protect the one. So therefore, they are now bringing in this particular measure to say that only in deserving cases, the anti-dumping duty will be imposed by the finance ministry, even when there is a strong recommendation by the designated authority. So therefore, the quality of examination, the quality of the applications, all will increase tremendously, because assessees will be now thinking, why should they spend money and effort in initiating an anti-dumping investigation if ultimately the levy is not going to be imposed by the finance ministry. Apart from this, the parliament also amended the anti-dumping provisions to bring in some discipline with regard to sunset review. As you all know, an anti-dumping duty, when it is imposed, it is valid for about 5 years and sun is supposed to set. If they want to renew this particular levy for further years, 5 years, the domestic industry will make an application and DA will examine whether the continuation of the anti-dumping duty is necessary to prevent injury to the domestic industry. Or cessation of the anti-dumping duties can cause serious injury to the domestic industry. While that provision is continuing, the amendment now made says the DA should finalize his finding on the sunset review well before 3 months before the expiry of the existing levy. And this is a good discipline, so that all of us will work against a timetable. It is not as though in the past, one day before the expiry, initiation will start, 18 months will take for the finalization, thereafter imposition of duties, all those things, etc. The finance ministry feels is not correct. So therefore, the way I look at it is the government is now trying to find a balancing act to protect the domestic industry, not necessarily by way of levy anti-dumping duties. For example, the levy of AADC is a huge benefit to the domestic industry. And if you also look at the number of commodities where the duty rates have been adjusted, it will all help the domestic industry producing the goods in India. Raw material will become cheaper, the finished good duty will be higher, and therefore there's a disincentive for the importing the finished goods, but incentive to manufacture them in India. So therefore, custom duties have been used as a good tool in the hands of the finance minister to encourage the production of domestic industry in India, make it as if the Make in India program is successful. I think I should stop here now.
Sir, thank you so much. That was literally a what we say, as incisive analysis of the budget provisions that we'll get, sir. Of course, we hope to do an even more in-depth session with you in the coming days. But sir, just one question I have for you, sir, because I want to take the benefit of your pearls of wisdom. For last 36 years, you've observed budgets at the very least, 36 to 40 years. You've seen several budgets in the aftermath of a crisis, be it a war, be it an emergency, be it the assassination of a prime minister, or be it economic crisis like 91, 97, whatever it is, sir, change of governments. This one is on the back of a black swan event. How would you rate this budget, sir? In a sense that 40 budgets you've seen, sir. How would you rate this one? Not in terms of numbers, but in terms of where we are as an economy, what the finance minister could have done given the constraints, and what she has done.
I think I will give the finance minister more than 90% mark in this particular case, 9 out of 10. Under the circumstances, what she has done probably within the, after all, she also doesn't unlimited resources. So you have to necessarily have the deficit financing has to be fixed. And what the economic boost has to be given. The fact that she has not disturbed the income tax rate itself is a good thing. And for providing the fillip to the domestic industry, also the SME sectors, what measures have been given are all in the positive directions. And the extension of the tax holiday for the startup is also good. So by accepting those negative things which I said, which need not have been done, that's why you get 9 out of 10. But under the fiscal measures, I think probably she has done a good job.
Sir, thank you so much, sir. We, of course, would want a full-fledged 90-minute session with you to understand the nuances of the budget in the coming days, sir.
That will be a very detailed one, nitpicking.
Yeah, we will do that, sir, in the next few days, sir. What a pleasure it is, sir, to listen to you. Always a pleasure to listen from the maestro himself, Advocate V. Lakshmikumaran, founder and managing partner of Lakshmikumaran and Sridharan Attorneys. Thanks so much, sir. One of the most eminent lawyers in this country talking on the tax provisions of the budget. Thank you, sir.
Thank you.